So a common issue I get from clients is I hear, I want to file an appeal. And so my question is, why? And typically they say, I just don't like the ruling. Now, I hope that means that there's some sort of legal error involved by the court, because not liking a ruling is not a reason to file an appeal. The reality is an appeal has to be filed based on judicial error. Listen to that, judicial error. So a lot of times people say, well, the judge didn't accept my evidence. So then I ask, well, how did you try to introduce that evidence? Now, I don't have a file here, but let's pretend I do. And then you say, here's my evidence, Judge. Look at it. It's all right here. This is all you need to know. If that's the way you try to present your evidence, that's why the court didn't accept it. You have to follow the rules of evidence and the rules of civil procedure. And the law treats you exactly the same as a lawyer who's been in business for 26 years. Now, you may say that's unfair, but the reality is it's not. It would be unfair to treat me differently and allow someone else to break the rules of evidence just because they don't have the experience. So should we treat a lawyer with 5 years of experience, give them, more chances than a lawyer of 26 years? The answer is no, because the law has to be equally applied to everybody. So there has to be judicial error, and that means you need to have a transcript. If there's no transcript, then hopefully there's a court recording, which can then be converted to a transcript. But a lot of courts are still using, the old method. The court reporter is still there, okay? But keep in mind that when you're filing an appeal, it is also a very complex issue. You have to go through the court's page where they're very specific, even to the size of the font and the spacing at the top of the page of how much I think it's an inch that has to be from the top. All right. Any questions or comments? Feel free to post them in the comment section below, and best luck with your appeal.